Good morning, everyone. All protocols observed. I'd like to welcome everyone back to JI Week. Today is day 5. It's our final day, and I'm very excited to introduce to you the Honorable DPP, Mr. Philip Bennetts, KC, who will be leading us on a very informative presentation on disclosure in criminal cases. The program, which includes the DPP's bio, will be shared with you in the chat. So I'd now like to hand over to the Honorable DPP, Mr. Philip Bennetts, KC. Good morning, DPP.
Good morning. I'm having a slight problem with the video. It reads, you can't start. I can't, there. Let me see if that works.
Yes, we can see you.
That works. Thank you, Emmanuel. Thank you very much for that introduction, and good morning, everyone. I have to extend my gratitude to the Lady Chief Justice for inviting me to speak this week in what has been a very informative week of very interesting topics. Disclosure is a challenging subject, and a subject both in England and Wales and here causes a certain amount of controversy. To start, can I go to the foreword of the DPP's disclosure guidance, which is dated the 14th of November of 2023, which we all will be familiar with. The foreword by the Honourable Chief Justice starts, the Office of the Director of Public Prosecutions of the Turks and Caicos Islands must be lauded for the commendable move of making and publishing this policy document, the DPP's guidance on disclosure in criminal matters. And that's how it was in November of 2023. And indeed, shortly before that, the Honourable Eugene Otone, King's Counsel, addressed during the course of the Education Week, addressed all on disclosure. That he did so on the basis that it was really to inform and conclude the considerations that he had on guidance, and as he said, to quote, to unpack the guidance. Well, I took up post on the 3rd of June of this year, and on the 4th of June, sorry, so 2 days in, I attended a meeting, bar and bench meeting, chaired by the Honourable Chief Justice, and disclosure was raised. I won't quote from all in that meeting, but what was said was by the judiciary that disclosure is a huge issue. Often it impacts in the middle of a trial. Cross-examination can't start until disclosure is made, when it should have been made long before that. Another member of the judiciary, the main issue is disclosure. The prosecution say they have asked the police and they have not got the material. It's one of the most vexing areas that the court experiences. And that was the theme on disclosure. The chief magistrate also saying that it was a problem in his court. So with that in mind, I want to go to the law that everybody will be familiar with and work through it in the hope of making suggestions that in due course can be adopted. Can I start with how is disclosure working at present? And a quote from Richard Horwell, King's Counsel, who was the author of the Moucher Report in July 2017. Disclosure problems have blighted our criminal justice system for too long. And although disclosure guidelines, manuals, and policy documents are necessary, it's the mindset and experience of those who do disclosure work that is paramount. That should guide all in the criminal justice system. You can have guidelines, you can have manuals, you can have policy documents, but it's the mindset and the experience of those who do disclosure work that is paramount. And that really is the starting point. And so one wouldn't criticize our guidelines, which run to some 26 pages, when, for example, the Crown Prosecution Service in England and Wales, the guidelines run to 30 chapters. But it's not so much the quantity of what's in the manuals, it's the way people deal with disclosure decisions. And what's at the heart of that is the disclosure test. Now, we're all familiar with it, but it's worth going to and stating that the prosecution are required to disclose material that might reasonably be considered capable of materially weakening the case for the prosecution against the accused or of assisting the case for the accused. It's quite a simple test. The criminal procedure rules inform the decisions on disclosure and the directions that can be made. Rule 45, I know we'll all be familiar with. The court has the power to make directions, fixing a date when the prosecution must disclose to the accused all the evidence they intend to rely on at trial. I'm not going to read the whole of Rule 45, but it's apparent from these rules that the court has a power and indeed has a duty to make rulings to ensure that disclosure is properly carried out. Rule 79 states that the prosecution must disclose to the accused any prosecution material used or unused which has not previously been disclosed to the accused. And it spells out, does it not, what the considerations are and have to be for prosecutors. 80 deals with disclosure by the defence. And when we go to Rule 80, it's apparent, is it not, for disclosure to work, there has to be disclosure not only by the prosecution, but also by the defence. And disclosure only works and can only work when both the prosecution and defence comply with rules and orders. Trial management, Rule 82, that gives the power to the court to deal with matters of disclosure. The next slide is a comment upon what has been observed some of the time, and that is there is perhaps a danger that the rules that we have just looked at have been interpreted in a much wider sense than probably intended. There have been occasions when a complaint has been made that a witness has gone beyond the ambit of their statement. Whilst this can be criticised as either poor statement taking skills and or poor preparation, not revealing the former, it's not a failing in disclosure. And it's very important when one considers failures in disclosure to correctly identify them. That's an example, in my view, of which is not a failing in disclosure. It is a different category of material in that if a witness in giving evidence goes outside their witness statement, there may be two reasons for that. And one reason may be that the statement is very poorly taken, and that should be picked up, and that should be picked up by the prosecution and should be dealt with. However, even if that has been done, there are always occasions where a witness will say something which is outside their statement. And that is something that just has to be dealt with during the trial process and is not a failing in disclosure. Can we then go to the start of the investigation and what really is at the heart of disclosure and, might I say, potentially the heart of the problems that are experienced with disclosure? The responsibilities of the police are framed by the guidance and the preparation of case file policy. And the former seeks to incorporate the criminal procedure rules with the relevant common law. The responsibilities can be distilled as investigating officers to ensure that all reasonable lines of inquiry have been investigated. All relevant material should be recorded and retained for disclosure purposes. And the material is recorded on either a document TCI 6A, which is the disclosure of non-sensitive unused material, or TCI 6, confidential information for the prosecution. We are now touching upon an area that, in my view, needs to be dealt with. Reasonable lines of inquiry. Reasonable lines of inquiry must be pursued by an investigating officer or an officer responsible for disclosure. What amounts to a reasonable line of inquiry will always involve considering the facts of and the issues in the case, including any defences raised. It's important that any inquiry is proportionate, reasonable, and necessary, and that involves consideration of what is expected to be found through the inquiry, to determine what is reasonable in the circumstances, how best to seek that information material, taking a proportionate approach, and being able to explain why it's needed. Relevance. The material must be relevant. A good definition is anything that appears to an investigator or the officer in the case or the disclosure officer to have some bearing on any offence under investigation or any person being investigated or on the surrounding circumstances, unless it is incapable of having any impact on the case. If there's any doubt, officers should include the item or ask the prosecutor for guidance. This includes not only material coming into the possession of the investigator, such as during a search, but also material generated by the investigator, such as interview records. Investigators should always err on the side of recording and retaining material where they have any doubt as to whether it may be relevant. Review of duties. Examining, inspecting, viewing, listening to, submitting schedules that fully describe the material and copies of disclosable material to the prosecutor. Just pausing there, submitting schedules, in my short experience of examining files, is an area where we are sadly failing in the prosecution of preparation of prosecution and those schedules should fully describe material. And we'll come to this, that that is a failing which goes to the core of the problems which were in part identified in that meeting on the 4th of June. Draw the attention of the prosecutor to any material considered satisfies the disclosure test. And then we deal with a full code test and consultation with the prosecutor. Consultation with the prosecutor is an essential ingredient of disclosure. And in my view, that communication is sadly lacking in many cases. This is an area which we will try and deal with. And in the past months, and even in the past few weeks, in talks with the police, we hope that this can be addressed. We hope that there can be the equivalent of a disclosure officer. In summary, one would expect that the investigation and the police would retain and secure all relevant material, record, review for relevant sensitivity and whether it meets the disclosure test, and reveal to the prosecutor on the appropriate forms. Can we come to those forms? TCI 6, confidential information for the prosecutor, and TCI 6A, disclosure of non-sensitive unused material. In fact, described in the prosecution policies as unusual, an unfortunate typo. But those are the schedules that the prosecutors are informed of the material upon which they will make decisions about disclosure. Prosecutors only have knowledge of the matters that are revealed to them by the investigators, and the schedules are the means by which that revelation takes place. Therefore, it's crucial that the schedules detail all of the relevant material and the material is adequately described. Descriptions on the schedules must be clear, accurate, contain sufficient detail to enable the prosecutor to make an informed decision on disclosure. Abbreviations and acronyms should be avoided, as they risk significant material being overlooked. We come back, do we not, to the point that one can have an enormous amount of guidance. One can have rules and regulations. But if the people who are charged with carrying out disclosure duties do not carry out those duties in the way that they should, the prosecution almost fails at the first hurdle. So the assessment of the situation as it currently is with the forms that are used, this is where the system very often fails. This is why the comments were made in that meeting, in part, not wholly, but in part. TCI 6A is part of a case summary document, and this comes on the very last page at number 18. It's a very small part of a larger form, and very often it's not completed, and even if it is, very little content is included. In some investigations that have taken place recently, the Crown Prosecution Service, MG forms as they're described, have been adopted. And it's my view that forms such as those should be adopted in the Turks and Caicos Islands, because they require detailed records of the material that has been retained. The prosecutor's role. The prosecutor comes to a file, as they now are, a paper file, and will look at the material that they have available and will, on that, make a decision as to whether material should be disclosed or not. A document that you see on the screens now is an example of TCI and TCI 6. And these documents aren't disclosable to the defense and the court. But in that is the document, and at 18 in this document comes the disclosure section. That document that was on the screen for a short space of time was a document from an attempted murder investigation. When it seemed to be quite a complicated investigation. And when one got to the disclosure section, there was not a single entry on that section, yet it had been signed by an officer. Now, that is something that's very easy, obviously, to pick up. And so the prosecutor's role in examining the file should reveal that. But what if the document that's completed it only contains a limited number of items? Then one has to, does one not, in carrying out the prosecutor's role, go back to ask to see all the material and review all the material. And in that way, what has been a root problem in a particular investigation can be cured at that stage. But a difficulty may be that requires time to do so. It has to be done. It's a duty of a prosecutor to do it. But in a system which is under stress, these areas have to be dealt with, and there has to be available material which assists officers to make entries of all the relevant material. The document that it's suggested may be helpful is a document such as this. This is much more detailed than the current document. And as you will see, it will list all relevant, non-sensitive, unused material. The relevant material is, that will be filled out. Record below the material of any kind, including information and objects, which is obtained in the course of a criminal investigation and which may be relevant to the investigation. And relevance is that it has some bearing on any offence under investigation or any person being investigated or on the surrounding circumstances of the case. Unless it's incapable of having any impact on the case, do not speculate. If it is not considered relevant, do not record it on the schedule. Give a sufficiently detailed description of the relevant material for the prosecutor to make a decision whether or not it should be examined. To the right-hand side of that, the material, the location of the material is noted. And then the decision of what the CPS role is, the reviewing lawyer, will then say and state on that document, D, disclose it. I, the defense, can inspect it. Clearly not disclosable, CND, or ND, document viewed and not disclosable. It's a very much more detailed document than the documents that are presently in use, and a suggestion, indeed a recommendation, that I will make is that we adopt the forms such as that. Going back to the prosecutor's role, it's helpful to set out what should be considered for disclosure at early stages of the prosecution. Any previous convictions of a victim. I mean, these are obvious, but need to be spelled out. Material which might enable the accused to make an early application to stay the proceedings as an abusive process. It doesn't matter whether such applications are rarely made. Material which might enable an accused to make representations about trial venue on a lesser charge. Material which would enable an accused to prepare for trial, which may be significantly less effective if disclosure is delayed. Names of eyewitnesses whom the prosecution do not intend to use. That's an area that may have certain sensitivity in the Turks and Caicos Islands, and one can understand that. And obviously there has to be matters such as risk assessment carried out before decisions like that are made. Other material to consider: records from tapes or recordings of telephone messages, for example, as in England and Wales, 999 calls, 911 calls, any incident logs, crime reports, record of note made by an investigator, CCTV footage, records in custody, previous accounts made by a complainant. We'll come to that area separately, and interview records. Documents to assist. There are two documents that, in my view, would assist the disclosure exercise. One is the disclosure record sheet. Forgive me. This is a document that I suggest might be helpful to adopt and to have in the Turks and Caicos Islands. You would have a disclosure record sheet. The purpose of it is to provide a written record of all events and actions that occur in the discharge of prosecution disclosure responsibilities. It should not be sent to the defense, but it is a record, and an important record, of what has been done. Should provide a clear record of what happens and when. Record, for example, the receipt of schedules from the police, consideration by the prosecutor of the numbered items listed by the disclosure officer, and all disclosure of material. Show the date of receipt of any defense statement, the resulting actions from it. A single record sheet should be completed in respect of sensitive and non-sensitive material. So again, a helpful addition to perhaps to the material that a prosecutor might be assisted by. The other document that might be of assistance to a prosecutor is a disclosure management document. This is a document that would be shared with the defense, and it would set out the details of the offence. It would set out what at an early stage are identified as the potential issues in the case. And it would then set out the following lines of inquiry. We deal with electronic material, third-party material. Electronic material I'm going to return to, but electronic material, and in particular, telephones, it is incredibly helpful if a document such as this is shared with the court, the defense, so that all know what is being considered. And for example, if there's a limited analysis of, for example, a telephone, the defense can say, well, actually, this is our defense, and we need so much more than that. And that can be dealt with at a stage long before the trial. And that, once again, hopefully prevents that unfortunate happening of mid-trial identifying material that may be relevant, that hasn't been disclosed, in that a decision made by a prosecutor but not revealed has led to material which the defense require because the prosecutor genuinely didn't realize that that was relevant to an issue, and therefore it would then be dealt with. The next slide is, it sets out really in detail what I have just been through, but it's more detailed. It sets out the disclosure management document, outlines the prosecution strategy and approach to disclosure, how the responsibilities have been managed, the prosecutor's approach to disclosure, including lines of inquiry, timescales for disclosure. All of these are areas that very often are a concern for defense attorneys. What has been done? How do we know it's been done? What investigations have been made? This deals with that. And at paragraph 3, transparency of approach is crucial, and it is. Transparency of approach means that one doesn't have the unfortunate happenings when a trial has started and there's a jury and witnesses and there's delay, because that delay is delay that should never, ever occur. Revelation of sensitive material. Sensitive material is material that, if disclosed, would give rise to a real risk of serious prejudice to an important public interest. Investigators must ensure that all relevant unused sensitive material is retained, reviewed, and revealed to the prosecutor. Going back to schedules and detailing on schedules, what material there is. Section 108 of the Evidence Ordinance is an interesting section, and in the context of sensitive material, I want to spend just a short time on it. Section 108 reads that no magistrate, justice of the peace, or police officer shall be compelled to say whence he got any information as to the commission of any offence, and no revenue officer shall be compelled to say where he got any information as to the commission of any offence against the public revenue or the excise laws. What does that mean? How wide is it? Does it mean, for example, that an application, for example, that's made for the details of the material that resulted in the issue of a search warrant should not and cannot be disclosed? Well, I know Mrs. Lara Maroof will be familiar with the case of the Queen Anne Cadet, which was prosecuted by Mr. Clement Joseph. And in that case, a firearm was found with ammunition and at the defendant's address. And he gave an account of coming in possession of the firearm and ammunition. But by time of trial, it appears that that wasn't his case, and application was made by Mrs. Maroof before His Honourable Lord Justice Baptiste for revelation of the details of the information provided. There was consideration of the case of the Queen and H 2004-2 appeal cases 134. But the judge concluded that section 108 was a statutory bar to revelation of that material. It's a section that perhaps has been considered many times by both prosecution and defence attorneys. The ambit of it may be wider than it might appear. I have no experience of it other than reading that authority. Applications for non-disclosure in the public interest, well, that ties in with 108 in that it is within the category of that type of material. But non-disclosure in the public interest. But the important aspect of this type of material is the fact that prosecutors should try and disclose as much material as they possibly can in order to ensure that there is a fair trial. And of course, if they are not in a position to reveal material and the judge is considering whether there's a fair trial, that may result in the trial not going any further. Third-party material is perhaps a difficult area. One has to, as both a investigator and a prosecutor, consider reasonable lines of inquiry, relevance, why it's relevant, consider privacy, and if relevant, is it proportionate and justifiable? Then to digital material. I imagine that this is an area that many attorneys have found difficult. In that there may be a vast amount of material and arguments both by the prosecution and by the defense that do not coincide. The consideration of that material, reasonable lines of inquiry, digital items should not be obtained as a matter of course. And just pausing there, there's the obvious considerations, for example, in sexual offences cases. A stranger rape, no association between the alleged offender and the complainant. One would struggle to argue that the complainant's phone should be examined. Contrary considerations might apply, would definitely apply, it would appear to me, if in fact there was a long-standing relationship and there was a conflict as to, for example, consent. We see an audit trail of all the processes followed. Now that is a very short bullet point consideration of digital material. The disclosure guidelines deal with electronic material and deal with considerations of a large quantity of digital material and how that's dealt with. The considerations in this area are important, and at present the guidance is perhaps not as detailed as it could be. It goes to the core issues. In dealing with material of this nature, there's obvious points to be made that no action should be taken which changes data on a device, which may be subsequently relied on in court. If it's necessary to obtain, to access original data, it should only be accessed by somebody who's competent to do so, and there's an audit trail of what they did. And the investigator in charge of the investigation has the responsibility of ensuring that the law and the principles are followed. There obviously is consideration of how material is obtained, whether by seizure or cooperation. whether and how long material is retained, and also considerations of legal professional privilege. Now, legal professional privilege is an area that can cause difficulties, and there needs to be a system of dealing with where there is suspicion of legal professional privilege material present on a device. There needs to be in place a mechanism for examining that. And that mechanism has to be completely separate from the prosecution team. And by that, I mean you would have to have independently instructed attorney to consider the material and see if there is privileged material there. And if there is, that's an end. Or if there isn't, then that material then can be accessed. It's inevitable, and there are various authorities on the point that when dealing with digital material, the extent of material now can be so extensive that there has to be sifting and dipping into the material. That process can only really be carried out with dialogue with the defense and the prosecution. So back to failings, potential failings I've touched upon. In last year's consideration during this week, during the disclosure talk, the case of Moucher was referred to, and we perhaps all know the details of that unfortunate case. There's murder of Lynette White in 1988, trial and conviction of 3 men, as it turned out, not 5. Convictions quashed because confessions obtained by bullying, no scientific evidence against. And in 2003, DNA revealed the killer. Investigation into the original trial resulted in a trial of police officers charged with conspiracy to pervert the course of justice. Trial problems, especially disclosure problems, documents could not be found, apparently destroyed, and obviously then there's suspicion as to why they've been destroyed. In fact, as it turned out, they had been destroyed not by malpractice, but for other reasons. But in any event, documents couldn't be found. The case failed. And as it was concluded, the evidence revealed a rather chaotic trail of poor management by police officers and prosecution lawyers. The recommendations made as a result of the report of Richard Hallwell, King's Counsel, was that national minimum standards for disclosure officers and accreditation process for disclosure officers. And here's a very important point. Disclosure is a specialism not an exercise in reading material and drawing up lists. It's a specialism. And consideration really needs to be made as to whether you have trained disclosure officers. In all training delivered, the significance of failures in disclosure should not simply be stated, but underscored by using appropriate examples. So look at the failures and see how those failures occurred and learn from that so that failures do not occur from then on. How disclosure requests are dealt with. There should be a log setting out the date of the request, the material sought, the relevance, and the issues to which the material goes. In my experience, that is an area where very often at trial, recording of requests sometimes just isn't done at all. Perhaps because the pressure of a trial, but putting a log in place so that any material disclosed is essential when one comes to a consideration of a case by the appeal court. And how and that deals with the requests. In the light of the comments made by Moucher looking at failings, I went back to the statistics in England and Wales, although it goes back some years. The number of prosecutions in England and Wales that collapsed because of failure by police or prosecutors to disclose evidence increased at one stage by 70%. And last year, 916 people had charges dropped over failure to disclose evidence, up from 537 in 2014 to 15. It comes after a recent collapse rape case highlighted a failure to share evidence with defence solicitors. The Crown Prosecution Service said the justice system had systemic problems. In the lead up to criminal trials, police and prosecutors have a duty to disclose evidence that might either assist the defence case or undermine the prosecutions. One point on this is that if a prosecution is proactive, it, as a result, can avoid many problems. It's when prosecutions become reactive that there then are problems. And a proactive investigation is one where all involved, investigators and prosecutors, communicate to ensure that during the process of the investigation, that the material is obtained, is recorded, and all is endorsed, so that all know where the material is, and all will know, that is, investigators and prosecutors will know what material is important in a particular case. Now, just an example, a general example from experience. Multi-handed historic sexual offences. My experience has been of cases where the investigation had not been proactive, And by the time of trial, it was very difficult to deal with, and coming up to trial, to deal with matters of disclosure and obtaining material that clearly have been obtained before, in contrast to a prosecutor advising at an early stage and advising on, well, for example, you have 30 complainants. All the material relevant to those complainants is categorized and able to be found with ease, so that when application is made or when the disclosure process is gone through, one can just easily extract that material and disclose it. Trial of Liam Allen, 12 counts of rape and sexual assault, halted. The case against Mr. Allen was dropped when it emerged evidence on a computer disk, which the police had looked through, showed messages from the alleged victim pestering him for casual sex. Now, either it was untruthful that they looked through, or they dipped through and did that in a way that very nearly caused a miscarriage of justice. Rape charge against Oxford University student Oliver Mears dropped on the eve of his trial after a diary which supported his case was uncovered. Surrey Police admitted its investigation had been flawed and launched an internal review. Chief Constable, for far too long, disclosure has been seen by many officers as something that is subsequent to an investigation. That is an administrative process at the end, rather than something that should be integral. He acknowledged it was no small task to train the police force to think differently, but an improvement plan would be published shortly. Although I see case analysis, that really says as much as needs to be said about it. Prosecutions, people who make decisions in prosecutions, must learn from cases such as that, which really comes to this. You obtain all the material before you make a decision to charge a person, all possible material. If in doubt, disclose. That should be writ large upon the walls of not only the disclosure officers or the investigation officers wall, and indeed the prosecutor's wall. So what does the future hold potentially? Training for prosecutors, training for police officers, closer liaison between the office of the DPP and the police. This goes back to the task force which was set up with that in mind. That is something that has to be taken up and taken up swiftly. It is in the process of being done. Develop specialist and experienced disclosure experts available to conduct sampling, local training, do local training and assistance in complex cases. pleased to have a good working knowledge of disclosure rules. Prosecutors to challenge poor quality schedules, including schedules that have no entries on them at all. And disclosure needs to be considered as an integral part of investigations rather than an additional responsibility added on at the end when preparing a prosecution file. Just one last word on disclosure so far as this is concerned. Disclosure is a continuing process that continues, obviously, throughout the trial, but continues after trial and post-conviction. Sometimes it's very difficult to understand how that takes place. Of course, the appeal process and preparation for the appeal process might reveal that. It is important, though, and one case I prosecuted illustrated that, and it was the effectively the assassination of a gang member. There had been an attack by the gang in one location, and later that day, the defendant walked into a public house, had a drink of orange juice, and then walked over and killed a member of the gang. For some unknown reason, when I came to prosecute that, the initial attack had been separated from the killing. And so I prosecuted the killing, and he was convicted and received a minimum term of about 35 years. I then had to conduct the second trial. I had no concerns about disclosure in the first trial. There was an enormous amount of material, but I had no concerns about it at all. But as I prepared for the next trial, I started to see material that I hadn't seen in the first trial. And that's just it's a good illustration of the continuing duty of disclosure. And so what I had to do was to inform the solicitors for the defendant who had been convicted that there was material, it was sensitive material, and that they should apply for leave to appeal, which they did. As it turned out, it was material that the Lord Chief considered together with others, and it had no effect on the safety of the conviction. But an illustration of the fact that the duty of disclosure continues. And that brings me slightly early, I'm afraid, to the conclusion of my disclosure comments.
Thank you so much, Learned DP. So we'll now open the floor for any questions or comments. So please feel free to ask the Honorable DPP any questions you may have on this topic. Thank you.
Hello, this is Laura Maroof.
Hello, Laura.
Hi, Ms. Bennett. I just wanted to because you touched on the issue of the evidence ordinance, section 108, I think it was. So
Yes.
you did you said that you're sure that you imagined that we had considered at length or on various occasions that section and how it applied. But I can say for my part, the first time I'd ever really looked at that section was in that case, and it was the Crown's answer to request for disclosure. The answer to the request for disclosure as to whether there was any relevant disclosure regarding the information that led to the search warrant was you can't get this, and the court can't make us give it to you, and we won't look at it because of section 108 of the evidence ordinance. And that was and that was the first time I, to be honest, really considered section 108. But now that we're aware of it, have you considered how that coincides with the Crown's duty to consider all disclosure in the case and to disclose any relevant information?
The Crown should consider all material. The fact that a statute might the reading of a statute might mean that certain material can't be disclosed, doesn't mean that the prosecution shouldn't consider all the material.
It would go back to a situation of if it was something that really should be disclosed, if the position is it can't be disclosed, they'd have to assess whether a defendant can still have a fair trial or not. So it's kind of a PII situation.
Well, it's an interesting section, but the considerations are the same. I mean, it's the same as a decision being made that there is sensitive material that can't be disclosed. Can it be disclosed in any form? If the answer is no, then can a defendant have a fair trial? And if the conclusion is the defendant can't have a fair trial, then that should be the end of those proceedings.
Right.
But if I understand your question right, it's does 108 does a reading of 108 mean that a prosecution advocate doesn't need to look at the material? I mean, if that's the question, the answer to that is no.
Okay, thank you.
Morning, DPP.
Good morning.
Don't you think section 108 should be revisited because it can be used as essentially as a sword to prevent the prosecution from providing information that may be extremely pertinent to a defense?
I'm certainly of the view that there needs to be consideration as to whether there needs to be legislation which covers certain aspects of an investigation. And my comments in respect to 108 is how wide is it?
Very
yeah, quite. And so it may be that I think we agree that perhaps it should be looked at, and also consideration as to whether there is legislation that's required which doesn't exist at the moment.
Thank you.
Can I ask another question, Lara Maroof again? Is there currently any training for the police or police that or senior police or officer in charge of disclosure in relation to their disclosure duties, what's used material, what's unused material, material that can be considered sensitive? Do they currently have any training in that regard, as far as you know?
Yes, there has been training in the past, and prosecutors have taken part in that training. As Ms. Joseph can confirm, the intention in the future is to have further training. And when I touched on the CPS forms, the MG forms, the UK England and Wales police officers have tried to adopt those forms in part, and they are going to carry out training as well. So they perhaps have the advantage of a more detailed recording system than we have at present. But training is all important. It really is an area where you have to have people who understand the law, and that's why it would be desirable, if possible, to have a disclosure officer. Now, there are suggestions that might be able to have a file manager disclosure officer to assess the files. So perhaps not in every single case initially, because as with all areas, the manpower is a problem.
Thank you.
Good morning, DPP. This is Justice Logan Jackson.
Good morning.
Thank you for that very thorough presentation. I'm very happy to see that you have the breadth and width of the problem in hand. The more difficult part is the solutions. And my question is along the lines of Defense Counsel Ms. Lara Maroof, in the sense that your reference in many times during the presentation was to, disclosure of relevant material from the police to Crown Counsel. Now, is there, as Ms. Maroof had a sufficient training for that officer to determine what is relevant, or is it a situation where all the material would then be disclosed to the prosecutor who decides? Because there have been cases in the past where quite innocently an officer would have failed to disclose certain things to the prosecutor in the case. It comes out in the middle of the trial, and then prosecution are then accused of hiding material or deliberately withholding material when the prosecutor, him or herself, had no knowledge of that bit of material until it came up in the trial. So the question would be whether or not there could be a system where the prosecutor has eyes on everything, being trained in the law, and then decides what is disclosable and what is not, rather than that lovely schedule is disclosed to the prosecutor and then important material is left off inadvertently.
There always has been a for some people a potential problem with the disclosure regime, and you identify that, which is relevance is all important, because if material is irrelevant, where does it go? And that's where sort of problems might occur. So it's two-pronged. You've got to have the training of the investigators and or disclosure officers, one, to deal with that, which is a very, very important area that you identify. And I know from the comments that you made at the meeting in June, these problems cause massive difficulties in trials with delay and consequent problems with witnesses, which is in certain cases here is just, it just shouldn't be encountered, because witnesses, we sometimes struggle to get the witnesses. And then the second strand of that is for prosecutors to be alive to examining the schedules and making taking a view as to whether the schedule it covers all material that it would appear to cover. I mean, that example of attempted murder case is just, that's very easy, because there's no material on the schedule, and I understand that's not the only example of it. And so then a prosecutor will say, come on, I want to have all the material. I want to examine it, because this process hasn't been gone through. And whoever has done it just clearly doesn't understand it. Be down to availability of time. It has to be that the prosecutor is confident that all material has been considered and all relevant material has been disclosed. And if a prosecutor has any doubt about that, then they must call for all the material or ask to examine all the material if there's a concern. And some cases the concern will be apparent, other cases not, and that's an area where there are dangers. I should just add that there are various meetings in the near future on disclosure. Mrs. Maroof and Mr. Smith, we're having a meeting to deal with that. So this is an area that has been identified for some time as one that needs focus, and we need to deal with it. And the police are alive to it as well. So hopefully there will be a way forward on this. And it's probably apparent from the comments that I made that a suggestion that I'll make is that the disclosure guidance needs to be revisited, not because it's bad as it is. It's just that it's the experience of all jurisdictions that the that there are problems throughout, and they're continuing problems, and it's a way of dealing with it. I mean, this year is, the example from England and Wales is of constantly reviewing and adding to their guidance. So it's definitely not a criticism of the guidance here. In fact, I have to say that the guidance is very focused and in a very short document deals with many things. But for example, from the UK, the Attorney General's guidelines on disclosure have been updated this year, and so it's one area. The guidance is one area that has to be dealt with, constantly updated, and then training is all important. But then it also goes back to mindset, and you can have all the guidance, but if the people aren't trained, then there will be problems.
May I ask if there are any further questions or comments? It doesn't seem so, Honorable DPP.
Thank you.
All right, so I'd like to say thank you very much for this morning's presentation. And I'd like to now invite Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, to give a formal vote of thanks. Ms. Carter.
Good morning, everyone. Good morning to our presenter, the learned DPP of the Turks and Caicos Islands. We wish to say on behalf of the JEI of the TCI, thank you for what was a very detailed and informative presentation on disclosure in criminal cases. Your expertise and very clear explanations on these issues involved were very much appreciated. Knowing disclosure to be an incredibly important topic in criminal cases, as it ensures that all relevant information is shared between both the prosecution and the defense. We also wish to say thank you for that, as well as we know disclosure serves to maintain the integrity of the criminal justice system and to uphold the rule of law, and your presentation definitely brought that to light. Thank you again for such an enlightening session and sharing your knowledge with us, and for going in depth into the law and the case law for us all to have a better understanding and appreciation on disclosure in criminal cases, DPP. So once again, I say thank you, and I now hand this back over to Mr. Emmanuel to formally close up this morning's session.
Thank you very much, Ms. Carter. That brings this morning's presentation to an end. We hope you will join us this afternoon. We have a bit of an earlier start. We start at 1 p.m. and we will examine continuing mental wellness. We also ask everyone to please join us for the JI Week closing ceremony, which will take place at 2:45 p.m. immediately following the continuing mental wellness seminar. So thank you very much for attending JI Week, and we look forward to your attendance at our last seminar. Good morning, everyone.